Recently, in a climate litigation case brought against the state of Montana, plaintiffs claimed that the state's energy policy, which supports fossil fuel development, violates their constitutional right to a clean and healthful environment. The case has been appealed, but the ramifications, if upheld, are far-reaching beyond climate change. To break it down for us today, please welcome John Benyon, who is the Director of Government Relations with the Washington Companies, and Brian Thompson, Associate with Browning, Calzac, Berry, and Hoven.
All right, thanks everybody. I think the chamber may have made a gross miscalculation here by putting two lawyers up here for a half-hour panel that we're already starting late with no moderator. And so we can talk forever. I don't remember what this panel is called, but I think we can rename it Fossil Fuel Filibuster. But we're grateful for this opportunity. There isn't a lot of time to cover this very, very important topic. In many ways, Montana has seen a national spotlight when it came to fossil fuel, climate change type issues this last year. And so the one thing with a limited amount of time, as Nancy already brought up, that we think that we can focus in is this state litigation that's working its way through the courts. And so I've just kind of wanted to turn to Brian and have him explain a little bit for those who need a little bit more context to what is happening if they've been reading about in the papers. What is this case? Who is involved? And what are some of the issues in play?
Yes. So the Held case, Held versus the state of Montana, it's important to realize where we're at. This is not in federal court. This is in state district court so far. It's been appealed to the Montana Supreme Court. The case was initially brought against the state energy policy, as well as regarding the provisions of the Montana Constitution ensuring the right to a clean and healthful environment. The Montana legislature last session actually repealed the state energy policy. That part of the lawsuit was then dismissed. What the court is really looking at is the legislature's responsibility, as delegated in the Montana Constitution, to provide for a clean and healthful environment in the state of Montana. I think that this case is really important in that it wasn't necessarily about any one particular act per se. It was brought by a group of youth plaintiffs, some of them under the age of majority, many just about 20 years old. Judge Seeley issued the order late summer, and it is on appeal to the Montana Supreme Court. I know both several executive agencies and the Montana Department of Justice are working on this. And I think that this is something that is incredibly impactful that Montana businesses should really care about, should really pay attention to. What the district court order essentially said is that the legislature, by enacting a couple of MEPA limitations, MEPA being the Montana Environmental Policy Act, it didn't uphold its duty to the citizens regarding the right to a clean and healthful environment. The court focused on greenhouse gases and the non-consideration under MEPA of greenhouse gases. There's a number of statutes that were enacted in 2011. Again, some more recently in the 2023 legislature, specifically House Bill 971, sponsored by Representative Kastmeyer, that limited the consideration of greenhouse gases in a MEPA consideration only where it was a regulated substance. Right now, it's not a regulated substance. It's not regulated on the federal level. It's not regulated by the state of Montana. Yet the court determined that by prohibiting the consideration of those greenhouse gases, that was a violation of the Constitution. This has ramifications broadly across Montana businesses. And I don't think it has ramifications just if you are a fossil fuel extractor or a electricity generator. I think it has implications much broader.
Yeah, I think you're absolutely right. I mean, this is something that, of course, the energy producing, the electric power plants, things like that have really focused in on the legislation, but for industries, manufacturing, even small businesses that rely on affordable and reliable power, this case could have some incredible implications. So the Washington companies, we have a copper mine in Butte. That's been running for the most part for many, many years. But one of the times where we actually had to shut down operations from 2001 to 2003 is when we could not afford or rely on the power that was available. And so this is an operation that goes 24/7, 365 days a year. It does not lend itself well to shutting it down temporarily, reopening it up. This is something that has to continually go forward. So when we look at the mine and the copper and molybdenum reserves that are there in Butte, we believe that the mine can continue on for another 35 years, and that's what we really hope to be doing. But the one question that keeps coming back to us is, can we have affordable, reliable power? So we're the second largest consumer of electricity in Montana. The first largest consumer of electricity is also in Butte. And so when you look at these operations that rely on power all over the state, whether you're big, you're a medium-sized manufacturer, if these kinds of cases going forward limit the options for having affordable, reliable power within the state, that's a big, big concern to the economy, to jobs, to our tax revenues, and all of that. And so there was this point where there was an actual trial. The state was able to put on evidence. The plaintiffs were able to put on evidence. I believe it was back in June was the trial, and the order came pretty soon after that. And there's been a little bit of a question since then at the district court level what happens. We know that it's getting appealed. But one of the things that aside, especially when they lose at a district court and are ready to appeal, that they try and do is say, can we get a pause on that? And do you want to talk a little bit about that, and also kind of what we can expect in 2024 when it comes to litigation?
Yes, so there was a request for a stay of the judgment and opinion at the district court order. There was a request for a stay at the district court level. That stay request was denied. There is another pending stay request with the Montana Supreme Court. Currently, to my knowledge, that has not been ruled on yet. I think I checked last night, and that still was the case. I think what is going to happen with this is a lot of uncertainty. We're not entirely sure exactly what the court's requirement stating that you have to consider greenhouse gases is going to mean. We don't know if that only applies to significantly large projects, such as a Colstrip generation station, or does that apply to much smaller government authorizations of things? What about every car registration that's granted by motor vehicles? What about any kind of housing development where they install gas heat or hot water tanks? That's going to have a greenhouse gas emission. That real estate residential development is going to have a greenhouse gas generation. It's not clear exactly which level of government permitting is going to require this analysis of greenhouse gases, and then what exactly that means. I think the true uncertainty really comes to the ability for third-party groups to cease a project, cease a development through an assertion that the government entity granting the permit did not review the greenhouse gases, and I kind of ask, to what end? It's right now it's not a regulated substance. It's not something that has an actual standard for now. As far as what the Montana Supreme Court is going to do, how that litigation is going to look, to some degree, your guess is as good as mine. The opening briefs are due about mid-February. And then they're going to have response and reply briefs thereafter. I would expect that we have an opinion from the Montana Supreme Court probably within about a half year from now, maybe a little bit longer, but I would guess certainly before the next legislative session. And I think now is really the time for Montana businesses to be reviewing what this case is going to mean to them, what the Montana Supreme Court opinion ultimately is going to mean, and how do we address these challenges coming up for the 2025 legislature. I think that should be a significant focus from the Business Caucus statewide.
Yeah, and I think this kind of case, because it got national attention, is going to draw a lot of participation in the Supreme Court appeal in the form of amicus briefs. So that's just a nice way of saying friends of the court, people that think that they have an interest in the outcome of the case and want to be able to say something, sometimes often not even make just purely legal arguments, but provide context for the court to understand the ramifications of a decision one way or another. And I know that business groups, including the Chamber, are looking at that as an option. And I expect you're going to see kind of record participation in this case. I also think that the Montana Supreme Court is aware of the significance of this case. And I think, and maybe it's more hopeful, that they will be mindful of their role in the government process, in the policy process. And that is that courts don't make policy. It is the legislature that makes policy. In Montana, we have a legislature that meets every other year. So right now, we're kind of in that in-between time. A year from now, the legislature will meet. But absent policy, really agencies like DEQ can't really do anything. The court can sometimes order it to reverse a permit or do something like that and go back to the drawing board, but then they need a set of rules with which to go by. The courts don't give them that rule. It's the legislature that gives them the rule. Up to this point, the legislature has said when it comes to greenhouse gas emissions, impacts for climate change outside of Montana, inside of Montana, we're not going to do that unless it is federally regulated. And there's probably really good reasons for that. But in the meantime, and I think what Brian is talking about, there's not just this litigation phase. The DEQ is undergoing a process. They've held some listening sessions as it relates to the Montana Environmental Policy Act. They have formed a work group that is going to have its first meeting in January, the end of January, where it's bringing folks from industry, it's bringing regulators, it's bringing folks from the environmental group to start talking about some of these things. And it might be challenging to try and find consensus within this work group, but the reality is the Supreme Court can do everything from a complete rubber stamp of what the district court did to a complete reversal and it's all for naught, or so many places in between. And we don't know what that is going to look like, but we do know that in 2025, I expect MEPA to continue to be a big policy topic at the legislature, for folks to understand what is it going to take to comply with whatever the court comes down with. And so shifting back to you, is there anything more that you think people should be aware of, both either on the litigation side or on how they can be more involved or informed when it comes to some of these big issues?
That's a good question. I know the Chamber itself is keeping a pretty close eye on this litigation. I know Charles Robeson and I have had many conversations about it. I would ensure that you keep in touch with your kind of advocacy organizations to see what's coming down the line. Another thing that I would be really concerned about is the breadth of this. If you're in an industry that doesn't use a lot of power or maybe isn't involved in fossil fuel extraction, this still may have an impact on you. This could impact transportation. This could impact the ability to build or develop. This could impact somebody's ability to get products to market. I think it could be broad-reaching, and I would encourage you to engage with those advocacy groups, really take a look at it. The other thing that I would really encourage you to do is talk to your legislators about that. There's legislators in every single one of your communities, and I know that they're paying attention to this. I've spoken to many about it. They put some effort and time and passed some legislation last year regarding MEPA, and it looks like that's going to have to be something that they do again. I would encourage you to pay attention to the working group, talk to your legislators, and really have your finger on the pulse of what's going to happen regarding greenhouse gases in their consideration and regulation in the state of Montana.
Yeah, I think the talking to legislators is a very key piece to this, because when you get into the mix of the legislative session, there are so many different important issues that are faced for legislators. There's budget considerations. I think that there's always kind of a top 5 issues that we can expect. Medicaid expansion, continuation of that, that's going to be one of the top 5 issues. Perhaps MEPA reform is going to be another one of those. But waiting until the session, which is another reason I'm glad that the DEQ is putting together this work group, getting the same certain people in the room, forming some relationships, having some good dialogue. That's the kind of stuff, and keeping legislators in the mix, and there are going to be some legislators on the work group, so that we can have some fruitful discussions. It's a little bit depressing that in all of that, when we get a court decision, when we get action by the legislature, whatever that may be, there's almost certainly going to be some litigation going forward. And that's one other thing that I'd be remiss if I didn't bring that up. As somebody that is involved in industry, oftentimes it's just a struggle to understand, what are the rules? What am I supposed to do? What are the timetables? What can I expect from the process? And so having that constantly changed and this kind of uncertainty is not a good thing for economic development within Montana and for people to make planning decisions going forward. When you consider energy issues, and we've talked mostly about energy producers, big industries, maybe small, but really when you look at the attitude of consumers, people that if you want to just pull up your phone and look at the weather app for the next week, what is it that's going to be heating their homes? When they're driving around, most of them still have gas tanks. They're filling up their gas tanks. They're still looking at pennies on the price of gas sometimes to know from one place or another which is cheapest. Energy and affordability, access to all that is always going to be a critical component to consumers and people's attitude about the economy as well. With that, do you have any other things that you want to?
I don't think I have anything other. Would you maybe want to take a question or two if we have a little bit of time?
Sure.
I'd like to make a comment. Well, can you all hear me?
Here.
Here we go. Well, I think I'm not a energy policy expert, certainly, but these projects have to cash flow. I was reading a lot about how green energy projects are just being canceled in some states because the investors it doesn't cash flow. You have to make money. And I think until we get to that point well into the future, hydrocarbons are going to be here for a lot longer than some people might think.
I would agree with that. If you look at our energy matrix in this state and in this country, that's still where a significant portion of energy usage comes from in this state. And the predictability, like you were saying, is really important. And I think that's what this case could impact. If you go out and you cite a project or you get the permits and you think you're well on your way to do so, and then all of a sudden you have litigation that stops the project, messes up your funding, and messes up your timeline for you to be able to generate revenue on that project, the cost just went way up. That impacts not only the owner of the facility or the owner of the generation or the owner of the person trying to move a product, but it also impacts the ultimate consumer.
Yeah, they're going to be here for a long time. I remember in 9th grade, this was in 1992, an earth science teacher told me, this is the year that we'll run out of oil. And we're well past that year, And so that was just like a major error on his part and maybe others part, but it's going to be around for a while. Montana, as I understand it, we're still in the top third when it comes to alternative energy as a mix to our statewide profile. I think that is going to continue to grow, but the reality is that those alone, without storage capacity and without the affordability, and by the way, copper mining, things like that, so that we can actually have these electric cars, so that we can have these windmills, so we can have the solar panels and all of those things, the critical minerals that go into that. We can't just rely on China to supply us those things. If we learned anything from the last couple of years, hopefully it's that if we're going to control our own destiny, whether that's energy, whether that's manufacturing, just the economy overall, the more that we're able to do here at home, we can do it better, we can do it more affordably and more predictably.
Speaking of critical minerals.
Thanks, John and Brian. So my question when I read the decision, one of the things that worried me the most is that a lot of the decisions were made on mental angst of the children. And there was no scientific standard for that. And what does that mean for businesses going forward if anyone can claim mental angst against any project?
Good question. I do recall seeing that in the order as well. That was a really interesting thing. It was one of the way that the plaintiffs showed damage. The court accepted that, saying that yes, these plaintiffs have suffered damage, including in the category of mental anguish. One of the more interesting things, this is a kind of a litigation thing that I thought was interesting, is that the defendants actually asked for independent medical evaluations of the plaintiffs so that they could defend against the claim that they had mental anguish, and the court denied the defendants' claim or attempt to have an independent medical exam so that they could at least contest that claim. That was a little bit surprising to me that the state wasn't even able to present competing evidence on whether or not the plaintiffs actually did suffer injury. I'm sure that'll come up in the appeal as well.
Yeah, I hope that a lot of what's contained in the order is just not something that people can cite to in future cases. But the central question, and I hope and think that the Montana Supreme Court will approach it in a thoughtful way, are some of these questions about the constitutionality of whether you can say, as a part of MEPA, that you don't look outside of Montana's borders, or you don't have to look inside the borders. So is there a requirement to essentially, must the legislature enact some policy when it comes to greenhouse gas when there is no framework from the federal piece? Should Montana alone kind of shoulder this global burden and lead the path when we don't know if anybody else is going to follow us? And so I hope that is how it's framed. I hope that's how it's teed up. But like I said, and not just to end on a sour note, but there will be a decision, there will be a legislative, some kind of process, and there will then be litigation after that. And so we just have to anticipate those things as best we can, help the people. I used to be in the AG's office, where we're giving the people that are defending our laws enough so that they can walk into the court and say, look, here's what we're doing. Here's the progress that we're trying to make, and we will never satisfy whatever kinds of mental anguish, those kinds of claims. We have to run a state here, and we have to have something that is viable for everybody. When you look at the Montana Constitution and the clean and healthful clause there, it is within Section 3 where there are a whole bunch of other rights that are spelled out there as well. And one problem with court cases is courts only answer the questions that are teed up right in front of it, versus the legislature, which has to balance all of these things, balance all of these rights, and make sure that we can have a society that we can live in.
Good afternoon. My name is Ryan Godwin. I'm a lawyer for the Navajo Transitional Energy Company that owns the Spring Creek Mine in Decker, Montana. And obviously, I know Navajo Transitional Energy Company is watching that case. But I guess my question for you, DEQ is going to go through its process this year and its listening sessions, and I think some small group committees to provide some technical expertise on what MEPA may look like in the future. But I think, in my opinion, the legislature probably needs to take some leadership in framing the policy decisions around that. Have you heard any indication as to what the legislature, some elements of MEPA, what the legislature may be looking for in 2025 when it has a packet of information from DEQ as to what would be helpful moving forward?
So there are a number of interim committees in Montana that, you know, they don't have a lot of authority, but they look at issues during the interim to learn themselves, sometimes to raise some kinds of solutions, but they can't pass solutions on their own. And so we have a number of different interim committees that can kind of touch on some of these things, the Environmental Quality Council, the Energy and Telecom Committee. There are going to be 6 legislators on the DEQ work group, as I understand it. There's 2 Republicans from each chamber, 1 Democrat from each chamber. I'm hopeful that those people, they can't speak for all of their colleagues, but hopefully they're in the mix because they are going to be in the driver's seat. The court may confine them and say, hey, you've got to do X, Y, or Z, but the court is not going to tell them how to do it. So you're absolutely right that legislators hopefully are driving the bus here at the end, and that the business community all the while is informing them, helping to educate on what kinds of impacts could come out of certain kinds of decisions. I know that we'll be doing that. I know that the chamber is going to be very active in that, and that there's an active role that the business community can play to make sure that there's some options at the end of this process.
And I think that there's still quite a bit of distance to go there to figure out what exactly happened. I mean, or what exactly to do next. An interesting thing to think about on this case is the timing of things. One of the pieces of legislation that was invalidated by the district court was House Bill 971, which was only in effect for about 3 or 4 months, and before the district court struck it down. That was a bill specifically aimed at MEPA. And specifically aimed at what could be considered in MEPA and what could not. So I think they're thinking about it constantly. I know I'm having discussions with legislators about it constantly, but the court didn't even let this one stand for 3 or 4 months before striking it down. In fact, the district court case was initiated years before this piece of legislation was even considered by the legislature.
Thank you. I'm George Harris. I'm the Executive Director of the Montana Coal Council, and I really appreciate this discussion today. Appreciate Brian being here and his comments as well. I think we need to look at the national implications as well. The case itself is impactful here in Montana, but it also has precedents that may be set throughout the nation. Just in the last couple of weeks, Senator Daines was in Congress trying to defend Colstrip, trying to defend NTEC, and trying to defend Bull Mountain. And one of the problems that he was identifying is that there seems to be a long game here, the long game to shut down the industry. And that is, they require OSM deadlines, and then they have the permit and the environmental impact statements that need to be met by a certain date, but there's the date when we're going to run out of coal because they're not allowing the permits to continue. And so the implication is far greater. He was hammering because they then moved the dates that they said they'd have the environmental impact statement done past the time when the coal availability would be exceeded in all of our major producers. So I think we need to be vigilant. We appreciate it, not only here at the state, but also nationally. Thank you.
So those are good points, and it's too bad that we didn't have time to go into everything that's happening at the federal level and what the EPA has proposed on things that would impact Colstrips 3 and 4, to the point of where both Senator Tester and Senator Daines have come out and voiced concerns over those plans that the EPA have that really seem to be targeted at Colstrip when you look at either the United States or certainly the western United States, where the rules are really geared towards just trying to shut down Colstrip. And so that we could spend certainly a whole nother half hour on that, but I think one of the reasons that we chose the Held case in particular is because it is significant in what is happening here in the state. It had a national spotlight on Montana. And also, the great thing about Montana, I think, is that we've got several legislators here. We often know our legislators, and I feel like you as individuals can have an incredible impact on the process by having one-on-one discussions with your legislators or showing up to a committee hearing and testifying, and the kind of impact that we can have on Montana policy within just with Montanans is really second to none, especially when you consider how heavy a lift it is sometimes at the federal level.
30 seconds, guys. Give us a quick soundbite. Is this decision, one way or the other, appealable to the U.S. Supreme Court, and what are the dynamics?
That's a really good question that I think many people are looking at right now. It's a Montana constitutional provision being interpreted by a Montana court. In most cases, that would be the end of the line. I do know that some people are trying to look at the complications that this order may have regarding other regulatory environments, including federal, including multi-state, including interstate commerce.
Yeah,
So, no, I don't know.
it would be hard to understand how the plaintiffs could, based on their own complaint and citing portions of the Montana Constitution. I wouldn't necessarily want to foreclose the option of the defendants if there was a particular kind of ruling, especially some kind of rubber stamp at the district court that it couldn't at least be teed up for something in the U.S. Supreme Court.
Thank you both for being on our panel, John and Brian. If there's one thing I'd like to reiterate is that we are very lucky in this state to have 1 degree of separation between us and our elected officials, so please take advantage of that. And one of the things I think that's been overlooked, maybe to date, is the significance of district court and Supreme Court races, and these are going to be very important as we go forward. So I really hope we all engage and become more informed and involved in those races.